All right. Welcome, everybody, to the estate planning webinar. My name is Ben Hewlett. I am a certified financial planner as well as a retirement income certified professional. And in a little bit, I will be introducing the presenter today, Duane Toney. So we are excited to dive into the estate planning basics with everyone. Just a couple things as we're waiting for people to come in. This will go through areas where we talk about the importance of why you, and frankly, why everyone should have an estate plan. You look at this and let's be honest, your whole life comes to fruition at this point, and this is not a time to drop the ball. And we'll go over some reasons why that's so important here in a bit. So as you can see here, we are based out of the Salt Lake area from the picture you can see. And then we work with people from California to New Hampshire, from Montana down to Texas. And it looks like we've got people joining us from all over the country. So it's fun to have you all here. So let's jump in. So we've got our SEC required statement here. We are Carson Wealth. We work with families and business owners throughout the U.S., and we help with both wealth and succession planning. So our goal is to help secure assets, build a legacy, and really just help you find your freedom. To get started and to shift over into the estate planning mindset, we have several different individuals here that you can see. You may recognize some of them or all of them, but my question for you is figuring out, what do these individuals have in common? So we've got Michael Jackson, Amy Winehouse, Martin Luther King, and Prince. What do they all have in common? If you guessed that they died intestate, you were correct. If you have no idea what intestate means, you are probably in the majority. Intestate means that you died without a will, and the state law then determines how your estate is passed on. So going through this, Michael Jackson, his estate took 12 years to settle. Amy Winehouse, her parents eventually received the assets, but they also received $2 million of her debts. Martin Luther King, as you can imagine, there's a lot of historical and sentimental value with his estate. That took a 50-year contentious battle between family members to be settled. And with Prince, it took 6 years and $3 million in fees to settle his estate. So again, the emphasis on why this is such an important area to protect yourself in those areas that you have. So here's our agenda for today. Again, I'll be introducing Duane here in a second, who will be going through this with you. So we'll be going through the estate planning basics, things to consider, strategies, the process and considerations for business owners, and then what to plan for next. So if you have your own questions throughout this, please go ahead and ask us questions. You've got a Q&A box. We're the only ones that can see that. So ask the questions that you have. We'll try to answer some of these when we get to the end of the webinar. If we do not reach all of the questions, if we don't go over all of the questions that you have, just a reminder that you do have a part 2 to get scheduled, and that is where you have a one-on-one complimentary session with an advisor, and we can get into more depth on your situation and the questions that you have. So go ahead and get that set up while there's still available times. Okay, I'm happy to introduce the presenter of today, Duane Toney. Now, Duane he's the managing director, partner, and wealth advisor of our Carson Wealth Salt Lake office. I've actually worked with Duane for several years now, and I've known him for a little bit longer than that. And I can attest that Duane is the calm in the storm. You'll get a feeling for that as he presents on the estate planning. So in my time, we've seen the year 2020, 2022, some of these crazy times, but Duane himself has almost 40 years of experience. So a lot of time in different storms over the last 4 decades. Duane is a CPA. He is a personal financial specialist, and he's also a certified exit planning advisor. He is experienced in helping families with tax reduction, financial planning, and business planning. So as you can tell from the picture here, Duane fits in well in Utah with 5 kids of his own and 18 grandkids. He enjoys spending time with his grandkids, traveling with his family, and running the business. So he also enjoys lap swimming, spin biking, and his new sauna. So without further ado, I'll turn the mic over to Duane, and he'll walk you through how to protect your estate.
Thanks, Ben. When you pass away intestate or without a will, you lose control of your estate, and so does your family. The celebrities who died intestate, they had something else in common. They were all very successful. They built significant estates, but they left no plan. You make sacrifices to build your estate. Your estate is for you and for the people that you love. An estate is emotional because it embodies the accumulation of all your decisions, your hard work, and their impact upon your relationships. We're here to help you to protect your estate and your assets for your family through an estate plan. Without an estate plan, you lose control of it. You're at the mercy of a probate judge and state law. So let's talk about how to keep you in control. So why do I think everybody needs an estate plan? Really, there are lots of reasons, but here are three big ones. First, you should be the one who decides who and how to enjoy and protect your assets. Second, you can proactively promote harmony in your family amongst your loved ones, and you can minimize tax burden. And third, you can prepare your loved ones to make wise decisions like you've tried to model during your life. While estate planning is so important, most people ignore it. In a recent survey, 67% of Americans said they do not have a plan in place, an estate plan in place. Our goal is to help some of the 67%. Maybe you're part of that. For those who have a pre-2018 estate plan, our next goal is to help you update that plan. And so it's not stuck in the past. Now, an advance directive or a living will is a written statement detailing the person's desires regarding their medical treatment if they're not able to make their wishes known. In a recent survey, 54% of Americans over 50 are unprepared if they find themselves in a situation where they cannot act for themselves. Even after COVID, only 46% of older adults say they have documented their care preferences in a legally binding way. I know a woman, I'll call her Sally. Sally did not have a living will. Her health declined, so she could not care for herself. Her daughter living away from her contended that her son living with her was taking advantage of her. This could have been avoided with a living will. You can have a much better experience than Sally by having pre-planned your big healthcare decisions. Okay, probate can be simplified and even avoided with proper planning. When I was a young CPA, I worked on the estate of a banker who died at age 82. His bank had a trust department and well-paid trust officers. Of all the people, he would have known how to simplify his probate estate, right? Wrong. When I arrived on the scene, his estate had been unsettled for a couple of years. I built a massive amount of spreadsheets to manage his equipment leases. His probate process went on for 6 years and his estate paid substantial professional fees during that time. Probate estates can be simplified through estate planning. Now, for the next section, what I want to do is I want to ask you some important questions. So these questions are to you, so get ready to ponder these. Okay, here's question number 1. Do you have a sound financial plan to ensure that you will have an estate? A sound financial plan is the foundation of a great estate plan. We're comprehensive fiduciary financial advisors. We're really experienced at every aspect of financial planning, and we love every aspect. On this slide, I've listed some of the most important aspects of a great financial plan. We assess the probability of all working out for each client. We coach and we clarify to build confidence for the future for each of our clients. We almost always can substantially improve upon a person's plan, however they come in with us. This webinar is not about financial planning, but suffice it to say, it is essential to build, protect, and enjoy an estate plan. So we're passionate about it. We love planning. Here's question number 2. Do you know how much your estate is worth? Most people think in gross terms when they think about the wealth they own, rather than what their net will really look like after taxes. Most people tend to consider just the gross estate that I mentioned. Subtracting debts and your other from your gross estate is a more accurate picture of your net worth. A good estate plan will minimize taxes and focus on reducing or eliminating high interest debt. Here's question 3. What would happen to you and your family if you are incapacitated tomorrow? Consider the following. Who can act for you with a legal power of attorney? How about a medical power? Typically, this should be 2 different people. Do they know your wishes in various situations? Are your wishes documented? And can they find them? Can they even get a hold of them in short notice? I've seen a strong woman seemingly pulled back and forth by those closest to her. After an extended period of time of not hearing from her, a court-ordered conservator showed up and closed all of her accounts. By taking action on these items, you can choose for yourself the person to act for you instead of ending up with a court-ordered conservator. Here's question number 5. Who do you need to support both now and in the future? Do you currently have any financial dependents? Will you in the future? Have their short and their long-term needs been planned for and documented? Who will care for the people who depend on you? The caregiver squeeze is finding yourself caring for someone in 2 or 3 different generations. One of my aging friends for many years cared for his wife during her time of decline. At the same time, he was caring for his special needs son. At one point, suddenly the son lashed out at his aging father, causing physical harm. The care for the special needs son was quickly reassigned to his siblings, which actually started to grow strong relationships among the siblings. We are very heartened when we see siblings step up and care for a special needs sibling, and when assets have been built for care for that special needs person. My wife and I care for our special needs brother-in-law. We have a special needs trust for him. His oldest brother is the trustee, and I am the financial advisor. Someday, our next generation, family members may need to step in and take over for our generation. We may need also a professional instead of a family trustee if he lives long. Question number 6. Are you part of a blended family? Blended families are a source of great hope for the future. Often the financial needs of a blended family are quite extensive, and estate planning, deciding who gets what in the event of distributions is super important. Avoiding contention is possible through proper estate planning. When considering blending 2 families, there are some important issues to consider. We see couples all over the board on these items. We encourage pre-planning, then making adjustments with post-planning as the years pass by. What was once important can reverse after many years together. Question number 7. Do you plan to help children or grandchildren financially? What about the needs of other people that you care about? There are many ways that grandparents can plan to assist their loved ones. When you're gone, do you want to continue to help someone? Must your assistance be earned? Is it need-based? Can it be revoked for any reason? Every family member has a different dynamic and a different approach. We've helped with tax smart strategies to benefit grandchildren with carefully planned contributions and distributions. We've helped with trust for special needs family members. Question 8, is there a charity, foundation, or cause you intend to support? There are many ways to make tax-wise contributions to these organizations. This aspect of planning can be deeply satisfying, comforting, and may leave a legacy that is very meaningful to you. You can donate before and after you pass away, and there are great ways to set up these contributions to minimize tax obligations. I still remember Alvina S. Barrett, who helped me with my accounting education through a scholarship at the university I attended. We've helped clients contribute to charity directly from their IRAs. We've helped them double up their contributions to avoid wasting the deductibility of contributions. We've helped with others contribute to donor advised funds with large contributions in a very high income year. And we've also had experience with private foundations. Now, question number 9. Do you know the potential tax liability of your estate? Here are some details for you to know a little bit about. In 2024, for federal estate tax, a single person's estate gets to exclude $13.62 million before taxes are owed. Then marginal tax rates quickly hit 40%. The federal generation skipping tax rate is a flat 40% when transferring the value above $13.62 million to generations after your children. The $13.62 million that I just mentioned goes down by 50% on January 1, 2026. So that's an important date to remember. In 2023, 12 states and the District of Columbia levied an estate tax, and 6 levied an inheritance tax. Good old Maryland leveled both of them. We put this in here because we thought it might bring a little bit of a chuckle at this point. Ocean view, or would you just prefer to watch them fight over your will? Sometimes the loss of a loved one brings out surprisingly strong opinions, emotions, and claims of secret deals that were made before a person passed away, like loans to be forgiven at death. The clearer you are ahead of time, the better. There are many strategies for reducing tax obligations through estate planning. In the following slides, I'll share some of those. Remember, every situation is different. In part 2, your personal session, we can look at your situation in some detail and determine which of these apply to you. Please remember to schedule your personal session in the Q&A box. So here we go. Here's strategy number 1, and that's spending down your estate. We have a client who loves to cruise. They were on an 11-week cruise when COVID hit, and I wondered if they would ever get home. I wondered if their 11-week cruise would turn into an 11-month or even longer cruise. Well, they made it home. There was no COVID on their boat. They paused for a while, and they're back taking wonderful cruises. Here's number 2, tax-free non-charitable gifts. When our clients contemplate gifts to family members, we encourage them to never make declarations of their future intent and never form a pattern. We found that declarations and patterns breed entitlement. A lack of each fosters thankfulness. So you want your family to be thankful. Number 3, beneficiary designations. This is super important and it can be dangerous, so you need to be careful with this. So a special needs child or an addicted child usually should not be included as a tax-qualified beneficiary in an IRA or 401k to avoid losing government benefits. Their portion can be higher in the non-qualified assets, like sale of real estate or an after-tax investment account. And those assets go into a special needs trust for them. Number 4, charitable trusts and transfers. There are many types of charitable trust, and there are 2 basic kinds that I just want to describe. The first is a charitable lead trust. where the charity receives income for a period of years, and then after those years, the family receives the remainder. The second type is a charitable remainder trust. With a charitable remainder trust, the family or you receives the income for a period of years. Then after those years, the remainder goes to a charity. Now, there are many types of variations of those two types of trust, but those are the two basic types. Here's number 5, joint ownership of accounts. This is often called the poor man's will. I call it a poor decision, unless you have only one heir. In between spouses, this is okay. Or with only one living child, this is okay. But otherwise, it is almost always a very poor decision, because that one trusted child, a joint owner on your accounts, may not follow your wishes after he or she inherits that asset. They may not treat their other siblings fairly. Number 6, transfer on death accounts. Transfer on death designations are generally for investment accounts, stating whom the account goes to when the owner dies. I call this the second poor man's will. It has some benefits, but it also has some danger. Payable on death accounts, number 7. Payable on death designations are generally used on bank accounts, stating whom the account assets are to pass when the owner dies. This is the third poor man's will. Marital transfers, number 7, are simply moving assets from one spouse to another for different purposes. Those purposes include lessening the overall liability risk, equalizing the value between the two spouses, and moving highly appreciated assets from one spouse to another. And likely it would be the spouse who would have the shortest lifespan to get basis step up. Now, what basis step up is when a person dies, their assets are in their non-qualified accounts are stepped up to the fair market value at the date of your death. So that's basis step up, and that's super important. Number 9, revocable trust. Nearly all estate planning trusts are at least initially revocable. They avoid probate, but offer few other benefits, other than they're easy to change. They do not protect creditors, and they do not reduce estate tax or income taxes. Number 10, irrevocable trust. A common irrevocable trust is an irrevocable life insurance trust. So you form a trust, you contribute money to the trust annually, the trust pays the premium on life insurance on you, the trust is the owner and the beneficiary. When you die, the trust buys assets from your estate to fund estate taxes, and the life insurance proceeds were collected by the trust without increasing your estate value. Other irrevocable trusts are to legally complete gifts to family members and move highly appreciated assets to your family. Number 11, marital and family trust. A marital trust is created for the benefit of a spouse, so thus marital. A marital trust is a type of irrevocable trust that allows you to transfer assets to your surviving spouse tax-free. It can also shield the estate of the spouse before the remaining assets pass to their children. A family trust is a specific trust for families to use to create a financial legacy for years to come. There are several benefits to creating one, including ensuring your family members receive your wealth and avoiding public disclosure of trust assets. These two, the marital trust and the family trust, are often companions in a great estate plan. Here's number 12, qualified personal residence trust. So what happens there is you put your prized residence in a trust with liquid assets that earn money to support it. So you ensure that the that the property is going to be taken care of and can stay in the family for a long time. So it's there to benefit your spouse and maybe even your children. It might also be a family cabin or a family compound. My wife likes the idea of a family compound. I'm not sure that I agree, but we'll see. Number 13, family limited partnership for family business. So here what happens is you put your business in a limited liability company. It's taxed as the partnership. You keep 1% of the voting interest and give away slowly 99% in a non-voting interest. And you do it over a period of many years, like I mentioned. You can give about $17,000 of value to each person each year, or $34,000 if you have a spouse. Here's number 14, spousal access trust. Here, you set up an irrevocable trust that allows you, the donor spouse, to gift assets in the trust to benefit your spouse and potential other family members, thereby removing the asset from your combined estate. It's a wonderful strategy. A great estate plan also includes instructions with your wisdom. Now, all these strategies in our house of many colors may not apply to you. So we're here to help you determine that. We can start in that part 2 session. Now, I want to mention some important things about choosing a professional trustee. A professional trustee is worth every penny that they're paid and can serve as a co-trustee or a successor trustee to an individual trustee. We feel the longer a trust will stay open, the more essential it is to have a professional trustee. Getting distributions correct, accounting, government compliance, tax return filing, being truly impartial, loyalty to the trust, prudence and investment management, and being accountable all add up to considerable complexity. All these can be delegated to a professional trustee. Now, we have discussed the above questions and strategies, and we've gone through a lot. So my question for you is, how are you feeling? What are you really leaving to your loved ones? Are you leaving a legacy, or are you leaving a mess? With estate planning, our job is to help you make wise, informed decisions and to ensure that those decisions are brought to life with a well-designed and communicated plan. The first step begins with analyze your lifestyle needs. Do you have the money that you need to live the life you want? Then we proceed through the remaining steps. We would also review your plan annually and make any desired updates. Estate planning is part of our overall proven process. The yellow highlighted items that you see here on this slide are additional parts of our proven process for planning. We strive to be excellent in our what we call our 3 uniques: coaching, clarity, and confidence. For business owners, perhaps your entire estate plan rests on the success of your business. For this reason, we offer planning services for business owners. Succession planning is the core of good business planning. In our proven process, we ask the business owners a series of curated questions, then score the business in various categories based on their responses to those questions. On your screen, you see a very typical score. It is very common to see some areas where financially successful business really do score well in 3 of the 5 areas, but it's also very, very common for them to score very poorly in the other 2. Through our process, the business is valued as of today and targets the potential value that it could reach if all those curated questions result in an A+ score. We then pursue a proven path to reach that A+ score. Again, succession planning is the core of good business planning and very highly impacts a comprehensive estate plan. As we wrap up, this is another quick reminder to schedule your part 2. for your personal session. So go to the Q&A box, click on that link, and schedule a time that works best for you. Putting together an estate plan is a gift you give yourself and your family. For you, it provides a path to freedom, both now and in the future. For your family, it gives security, reassurance, and answers. This is a gift that keeps giving for a long, long time for you and your family. I've loved being with you. I want to thank you for being here with me today. And I look forward to getting together with you in a part 2 session. So thanks again and have a great day.